It should be pretty quick.
What is today, the 18th, 17th, 18th?
Good morning, everyone. Welcome to the Ag Committee meeting this morning. I want to call your attention to our decorum responsibilities here. Please address the chairman and keep your cell phones off. That's about the main thing. So anyway, we'll have a roll call.
Representative Banks.
Here.
Representative Davis.
Here.
Representative Eklund.
Here.
Representative Johnson.
Here.
Representative Ottman.
Here.
Representative Provenza.
Here.
Representative Schmid.
Here.
Representative Strock.
Here.
Chairman Winter.
Here.
Across the way it is. So I'm not sure.
Thank you.
Well, this morning we're going to start out with Senate Bill number 82, and we have Senator Steinmetz here to present the bill for us. Senator Steinmetz, welcome.
Thank you, Mr. Chairman, and if it's all right, I would also invite Director Mead from Water Development up as well. He has more of the technical expertise than I do, and we also have the construction bill up in Senate Agriculture at 8 o'clock. So we're hoping to be brief, and I'm hoping if I could present this bill to you, and then the temporary water use agreements, give you some comments on that, but the state engineer's office is here as well on that, but just to make clear those two bills. So with that, Mr. Chairman, I'm sure you all have your notebooks and you have reviewed those over the weekend. And this basically just gives you the high-level overview of the projects that are all good projects that have been vetted by your Select Water Committee and the Water Development Commission. So you can see spending from account 1, account 2, and account 3. So $534,998 out of account 1 for the Hewlett Water Master Plan and the UW Water Research Program. Then in Water 1, also on the level 1 projects rehabilitation section, you have a total of $980,000 on that. And your level 1 projects, dams and reservoirs from Water 2 is $551,000. And so that's basically your projects. If you want more detail, it's in your notebooks, or the director could answer those questions, but it's a good bill, smaller than sometimes in the past, because as you know, we're taking the Board of Control budget out of Water 1, which they replenished last year, but it has had an effect on how much funding we have in the Water 1 account. So hopefully in the budget session next year, we can correct that. So, Mr. Chairman, I would stand for any questions, or let the director or give you my comments on the temporary water use agreements, and then head across the hall.
Does the committee have any questions for Senator Steinmetz? Would you go ahead with your presentation?
Mr. Chairman, members of the committee, Jason Mead, Director of the Water Development Office. I really don't have a lot to add unless you have any specific questions about particular planning studies. I could sure answer those.
Okay. Any questions for Mr. Mead? Representative Eklund.
Mr. Chairman, I see on here you've got the Middle Paposia River Storage Study. Could you tell us a little about this? Because I'm guessing it must be one of the, or a look at the water storage in that around the reservation.
Yeah. Mr. Chairman, Representative Eklund, this is a project that's sponsored by the Enterprise and Taylor Watershed Improvement Districts. But really, it's a group of folks that are part of the Healthy Rivers Initiative. So it's the Poposia Conservation District, the local agricultural irrigators, Game and Fish is involved, Forest Service has been involved, a number of different entities, including the city of Lander. And really what they're facing is in the middle Poposia River, the Poposia River in general, they have low flows during irrigation season, which cause water quality issues. They also have potential need for future water for the city. And so it's really a grassroots group effort to look at what can they do up there. And originally they're looking at Worthen Meadows and a potential enlargement of Worthen Meadows. But as we all know, we can't just set our sights on one particular reservoir site and trudge forward and think we can get it permitted. We've kind of got to look at the entire spectrum of possibilities of how to address those issues. So that's what this particular study is going to start off looking at.
Any more questions for Mr. Mead? Seeing none, thank you very much.
Thank you.
Senator Steinmetz, do you want to present yours right now?
Mr. Chairman, if that's all right, I just would give you my comments on Senate File 43 while I'm here, because the good state engineer is here and I'm sure he can help you a lot with this bill after I leave. But this bill, Senate File 43, my comments on that, the reason we brought this bill forward is because we have the ability to have a temporary water use agreement or a permanent transfer. And these temporary water use agreements have never been limited in any way. So they could just be renewed and renewed and renewed and almost be like a permanent transfer. So this bill seeks to limit those to 5 years, which is 2 years is current practice, but this would seek to 5 years because that lines it up with the abandonment statutes. As you know, we talked about that earlier this session, that it's 5 years, you have to use your water, or you could be subject to abandonment if somebody would call for that. So basically what this does is it limits the temporary water use agreements to 5 years and then to 10 years in total, so that if you are going to keep renewing and renewing and renewing, you need to go get a permanent change rather than just keep renewing a temporary permit. One of the things that we discussed a lot in Select Water was, does this apply to in-stream flows? And it does not. The state of Wyoming is the only water holder that can have an in-stream flow permit. And so it doesn't affect in-stream flows at all. You can't just do a temporary change of use for in-stream flows. That was something of a lot of discussion. So basically, if you look at the bill, and on the bottom of page 1, for a period not to exceed, and then you go to page 2, 5 years, for temporary beneficial purposes, the state engineer shall not approve a temporary transfer if it injuriously affects the water rights of other appropriators prior to the expiration of a temporary transfer, and upon the applicant's request, the state engineer may, in his discretion, renew temporary transfers for successive periods with no successive period to exceed 5 years, and then the total length of the transfer couldn't exceed 10 years. The problem was the state engineer had no discretion at all with this, and people were just renewing and renewing and renewing. So that's the problem we're trying to fix. This bill is the solution. We've worked on it for a couple of years, but I did just want to give you that background before I went across the hall to the other meeting.
Any questions? Yes, Representative Strock?
Yeah, thank you, Chairman. What was the problem with people just being able to renew and renew and renew? I guess I'm not understanding.
Mr. Chairman, Representative Strock, it is a problem because the state engineer doesn't have any discretion to deny that. So the feeling of Select Water is, if you're going to renew and renew and renew, you really should have a permanent change of use rather than keep renewing temporary changes.
Go ahead.
Thank you. So if it wasn't in-stream, who was renewing these? I guess, were they businesses or oil field? I know you took out a bunch of wording here. So who was doing the renewing, I guess? is what I'm
Mr. Chairman,
curious.
I think I would like to have the state engineer's office address that because I don't have those specifics in front of me and I don't want to make a mistake. All right, thank you.
Any more questions for Senator Steinmetz? Thank you very much.
Thank you, Mr. Chairman,
Appreciate
and
you
I'll
being
give you
here.
back your bill.
Okay, thank you. Okay. Do we have any other state agencies that would like to comment on the House Bill 82 or Senate File 82? Did they come forward? Does the state engineer want to talk about this at all? Yes. You what? Okay, thank you. So, Mr. Mead, do you have anything else to tell us? Okay. Any questions for Mr. Mead at this point? Okay, what's the pleasure of the committee?
Do we want to take public comment?
Oh, yeah, right, okay. Sorry. Public comment. Anyone want to come forward and testify at this about Senate File 82? Getting in a hurry here.
Good morning, Mr. Chairman.
Good morning.
Mr. Chairman, members of the committee, my name is Chris Mickey with the Wyoming Business Alliance. I'll be very brief as looks like I'm probably the only one that wants to talk about it. So we support this bill. We have businesses all over the state and all different industries, and we understand how important water is to the state of Wyoming. And as this committee saw a couple weeks ago with the construction bill, having well-vetted and well-planned out projects is very important. And so we just encourage you to pass this bill and so that, future legislatures can take these projects and be able to move forward with them with a well-planned out project. So with that, I'll open it up for any questions.
Any questions for the Business Council? Seeing none, thank you very much. Okay, any other public who would like to testify at this time? Okay, how about let's see, is this one online for, no, it's 82, isn't it? Okay. Okay, thank you. So I guess we can close public comment on Senate File 82. So what is the pleasure of the committee?
A second.
Did you get it there?
Second by Ottman.
Mark, you have that? Okay, thank you. Okay. Okay, the question been called for. All those in favor of moving the bill forward signify by saying aye.
We need a roll.
Oh, okay, sorry. Go ahead.
We're voting on Senate File 82, no amendments. Representative Banks.
Aye.
Representative Davis.
Aye.
Representative Eklund.
Aye.
Representative Johnson.
Aye.
Representative Ottman.
Aye.
Representative Provenza.
Aye.
Representative Schmid.
Aye.
Representative Strock.
Aye.
Chairman Winter.
Here, aye.
9 ayes, no noes. This would pass.
Okay, thank you. Okay, do we have any discussion from the committee about the bill?
That one's good. We're done.
We'll continue testimony on this temporary water use.
Don't we need to finish the 82? We have. We just already voted on it. Okay. Okay, Well, is there anyone who'd like to speak on any agencies anyway that would like to testify on House or Senate File 843? Thank you. Good morning.
Good morning, Mr. Chairman. I'm Brandon Gebhardt, State Engineer.
Mr. Chairman, good morning. Members of the committee, my name is Chris Brown. I supervise the water section of the Attorney General's office.
Would you go ahead?
Thank you, Mr. Chairman. As Senator Steinmetz mentioned, this bill has been in the process for a couple of years now. But really the reason behind it is, from my perspective and being involved in some of the things that I've heard, is people wanted clarity and certainty. And I think that that's what we ended up with. But there's a couple of things going on. So people wanted a tool, a flexible tool, for a couple of reasons. One, you have the temporary use side. The idea is a flexible tool that they could use for a temporary purpose for an amount of time, rather than going and getting their own water right that could not, or maybe not be in priority very often. They wanted certainty that they would be able to use a supply of water. Couple of examples, oil and gas here in Laramie County. They've made a lot of agreements with irrigators to purchase certain amounts of water for their operations. The other side of it is people who want to use this tool to allow them to preserve their water right, enter into these agreements, create the use, or be able to show that they're still using the water right. But they may have a situation where they have to, or they think that their existing use may be changing in the future. Let's think of, say, a power plant whose use is changing, whether they are shifting how they're making power or taking units off a line or something like that. But they want this tool because they do think that in the future that they're going to change that type of a use to something else. And sometimes that takes a period of time for that to develop. So those are kind of two of the circumstances that we're seeing. And so the changes that people were seeking in this amendment were for both of those purposes. I think what this does is this does clarify how and what these temporary uses can be used for. The other thing I would point out that Senator Steinmetz mentioned, the reason for the 5 years ties back to the abandonment. That's not exactly my recollection. I do believe that the temporary water use bill, or the temporary water use statute currently, and as it's presented in front of you, it provides that protection from abandonment. The 5 to 10 years was just a number that the committee selected to limit these. And so I don't think that it's necessarily tied to abandonment, because that was part of the certainty that these folks were seeking, is that if they enter into this, they want to make sure that their underlying water right isn't abandoned. And that's what this temporary water use agreement does. And Chris was along for the ride on most of this, and actually the AG's office through Chris helped prepare the bill. And maybe is there anything you want to add to what I've said?
Mr. Chairman, members of the committee, maybe just one little point of clarification. I think goes somewhat to Representative Stock's question to Senator Steinmetz. In just trying to provide some additional clarity, there was some thinking that the existing language in the existing statute, because it specifically mentions some temporary purposes. It mentions highway construction or repair, which is why this bill originally, or why this statute originally became enacted in about the 1950s. help facilitate construction of the interstate highways to get the water that was necessary for that purpose. And then over time, railroad, roadbed construction, and the drilling and producing operations were added to the statute, but has a catch-all. And it says, or other temporary purposes. And the feeling was amongst some of the users that perhaps that was confusing, that some folks out there that might be in need of a temporary supply thought they would be limited to the specifically enumerated items and perhaps not understand that they could also satisfy another temporary purpose. So the goal behind striking out the specifically mentioned items and just leaving the catch-all, temporary purposes, would remove that uncertainty or that lack of clarity. And you'll see that the title of the statute was changed as well to remove those specific items. So that's one of the clarity items that the group sought to clear up with regard to this statute. So that's just another piece that they attempted to rectify with this bill.
Thank you. Go ahead.
Mr. Chairman, and I'm reminded of another discussion that Representative Strzok brought up, and that's the continual renewal. And I think Senator Steinmetz mentioned that we don't have the authority to stop these under those circumstances. And I will disagree with that, because right now, a temporary water use agreement is for 2 years. They can come back in with a new application that we would completely review as a new application. It acts like an extension, but it is reviewed. And so if we're seeing that this arrangement is looking to be like it's a permanent supply that people are starting to realize and rely on, then we have taken the steps to say this is starting to look more permanent. You need to start seeking a change of use through the Board of Control rather than using this as a tool. So we currently have that ability to review that temporary agreement so that it is not just a change, a permanent change. So I just wanted to make that clarification too.
Thank you. Representative, excuse me, Representative Provenza.
Thank you, Mr. Chairman. We have an amendment here that the stock growers brought that has excluding beneficial use of in-stream flows identified in 41.3/1001. My understanding is that there's an opinion from the state engineer's office that says that these water use agreements can't be used for in-stream flow. Is there any concern about in-stream flow having to do with this bill? Does it touch on it at all? Do we need to have an amendment? I'd just like to hear your feedback on that.
Go ahead.
Mr. Chairman, Representative Provenza, we've testified to this a couple of times now. And it is the state engineer's opinion that we do not need the exclusion of in-stream flow for a couple of reasons. We also have an AG opinion that I'll let Chris talk to in a second, but a couple of things with an in-stream flow. The first is that it has to be owned, the statutes for in-stream flow, it has to be owned by the state of Wyoming. It is not, and then in-stream flow is not a temporary purpose. So under this statute, it has to be used for a temporary purpose. It's always been viewed by the state engineer's office that that is not a temporary purpose. To further that, legislature through changes have known about that interpretation and have never done anything to change that. So we have continued with the understanding that legislature agrees with that interpretation. And so we would not allow these for a temporary or for an in-stream flow. And like I said, there was also an AG opinion on that, and I think Chris can speak to the AG opinion.
Would you go ahead?
Mr. Chairman, and the state engineer is absolutely right. So this issue came up in front of the state engineer's office quite a number of different times in the early 2000s, specifically an area in Division 4 in the Pinedale area to 2021 or 2001, 2003. At any rate, there's been efforts in the past to use the temporary transfer statute 110 that's in front of you today in order to satisfy an in-stream flow. The state engineer at the time had denied those requests, those applications in order to get that done, but he kept getting them. And he kept getting pushback that the law allowed it. So in 2015, he asked for a formal opinion from the Attorney General's office, Happy to supply that opinion to the group. The Select Water Committee had that opinion in front of them. But the opinion came to the conclusion that neither this statute, the temporary transfer statute, or the in-stream flow statutes allow for the temporary transfer for an in-stream flow purpose. And that's the nutshell, that's the conclusion. And so it's the Attorney General's office opinion that this statute cannot be used for the purpose of an in-stream flow.
Okay. Any more questions for the? Yes, Representative Eklund?
Mr. Chairman, I can't get my machine to work here. There it goes. So I'm gonna ask the same questions I did the last time we worked on this thing. Can this in any way affect the junior rights holders? Do you see any circumstance at all where the junior rights people could be damaged in this? And I'll go ahead and answer that, I guess, and I've got to follow up with it too.
Okay, go ahead.
Mr. Chairman, Representative Eklund, I would say that the statute protects the junior user if it does impact them. It allows even a junior user to require that it be investigated to see if the operation of the temporary use agreement does impact them. And I would say that the way that is viewed is if the underlying right were in operation, does that still injure the junior user? If not, then the temporary can continue. But if, because it's under a temporary use and just that function does change it, let me back up. So I think an investigation would go out and look at the situation. If a junior is injured, then it is shut off. Under current statute, it's shut off immediately and then an investigation occurs. And if in that investigation, I think what I have heard our field folks do is they will go look at the situation on the ground as it's shut off because a call was made, that they would go and they would evaluate it from the perspective that if the underlying water right was in use without the temporary, then that injures the junior, then that is in priority. So the original way that it should work, that they take the temporary agreement, and Chris might have to help me clean this up because I'm stumbling. But they would look at it from the perspective that there is no temporary water use agreement. The underlying right is using the water the way they would have it. Does that injure the junior or not? If that does not injure the junior and the priority, Chris, please help.
Yes, sir.
I'm
Mr.
struggling.
Chairman, to answer your question, Representative Eklund, the statute protects a junior user in two different ways, and this bill does not change that. So the first way that a junior user, and so when we're talking about a junior user, we're talking about the users in relation to the right that's being transferred, so the from right, where the water's coming from. So we're talking about priorities in relation to that right. What the statute says, what it currently says, and what's not being changed by this bill is that when an application comes into the state engineer's office, the state engineer must do an assessment to see whether or not the proposed transfer injures any existing appropriator. That includes both seniors and juniors. So an assessment is done with regard to the application to see if any injury on the basis of the application, looking at the water rights records to see if there can be an injury to other rights. But we all know once things get on the ground that something might occur that a review of the records didn't reveal. So on the back end, and the state engineer is probably not remembering that the Senate committee pulled out the changes that had been proposed because we had, working through the 2-year process, proposed that there be a little bit different treatment between senior users and junior users. That's not in the bill in front of you. The committee on the other side took that particular change out. So the way it stands now is that if any existing appropriator believes, once a temporary transfer is in place, believes that it's injuring them, the temporary transfer gets shut off, the hydrographer commissioner, the water cops that are out there to put in place these temporary transfers, do an assessment and assess whether or not that temporary transfer is in fact injuring another appropriator. And if it is, it stays off, and if it's not, it gets turned back on. And so you have both the front end review and you have the back end review to assure that it's not harming existing appropriators, both junior and senior.
Follow up?
So I'm trying to, it seems like a beneficial thing for all of the appropriated water rights. I'm still trying to figure out why there's opposition and concern about this bill by the Upper North Platte and the Little Snake River drainage folks that just aren't sure they like it very well. And I guess I need to know, is this thing tight enough that we can rest their concerns and maybe even benefit them by passing the bill? I guess you may have already answered it a couple times and I keep making circles, and I apologize for that, but not sure I have my head completely wrapped around this thing.
Go ahead.
Mr. Chairman, Representative Eklund, I don't know that I've heard concerns other than probably the stock growers is trying to address in this amendment. But I wonder if you might not be getting confused with the exchange statute and not the temporary water use agreement, because I did order an exchange in that area, and that has been protested. But I'm not remembering significant concern from a similar group with the temporary water use agreement. I could be wrong, but I do know that they had a concern with the exchange that I issued in that area.
Yes, go ahead.
I don't think I'm confused on it. We'll probably have other testimony that might clear my mind a bit. The other aside question is, so in Laramie County, I believe most of these temporary uses are for oil and gas, and they're groundwater, not surface water. Am I correct on that? And in that case, the groundwater is generally sold somehow. Is this the same way? Are these temporary waters that are secured by whoever needs it, are they sold to them by an appropriator, like an irrigation appropriator of the surface water?
Go ahead.
Mr. Chairman, Representative Eklund, yes. In Laramie County, we do see quite a few of these, and it is the same format, except that it is just using groundwater. So an irrigator could forego irrigating his land and make an agreement with an oil and gas to provide them that water that is tied to only the consumptive use portion, because they do take a haircut, and the statute says 50% or as determined, because of the return flow situation. But the consumptive use portion can be used to enter into an agreement with, say, an oil and gas, as we see in Laramie County. Does that answer your question?
Yes, I think so. So the same thing would happen on surface water as groundwater. There could be a sale of some appropriator's irrigation right, or whatever they use.
Mr. Chairman, Representative Eklund, yes, they would forego their use under the underlying water right to make that amount of water available for such as an oil and gas operator.
Any other questions for the water folks? Okay, thank you very much for being here.
Thank you.
Are there any other state agencies like to testify? Okay. How about the public? Would they like to come up and testify? Mr. Magagna.
Thank you, Mr. Chairman. Jim McGadden with the Wyoming Stockholders Association. We've been involved as this bill has evolved over the past 2 years, 2 legislative sessions now, and certainly concur with the need to update the current statute with regards to temporary uses that's been in place for so long and had a very narrow purpose when it was originally put in place. There have been some meaningful changes made to this bill as it's moved forward. The one that Representative Eklund referred to, protections for junior water right holders. There was some language that concerned us in there on that that's been removed since. So I think that in general, the bill has moved forward in a positive direction. Having said that, I'll address the proposed amendments that I have in front of you at this time. And the first one specific related to that, reinserting the language that after purposes on page 2, line 17, that says excluding the beneficial use of in-stream flows identified in WS 41.3.101. That prohibition against in-stream flows has been part of this bill from its origination and continued to be part of it until action taken this year in the Senate that removed that language. We would concur with the earlier statements made to you that there's been a state engineer say that that's not an appropriate use of in-stream flow. There's been an attorney general's opinion on it. Having said that, we still remain very concerned that with that language removed, there will be future attempts, perhaps with different state engineers and attorney generals, to expand temporary use to include in-stream flows. And so we think that retaining that language in the bill, as has been done until just a week ago throughout this process, is critically important to letting anyone who's looking at potential temporary uses understand that that simply is not a permitted use, that's in contrast with the temporary use statutes for in-stream flow statutes that we worked on very carefully over a number of years to put into Wyoming legislation. And this may be redundant. In legislation, there's not a problem with redundancy. Having it stated clearly in the statute is much more secure than simply relying on the opinion of a state engineer and the opinion of an attorney general that can both change over time. So we would, our support of this bill would depend on that language being reinserted just as it was previously. With regards to the second amendment that I've proposed to you, the bill is very clear that you can only do in-stream flow, I'm sorry, Mr. Chairman, you can only do temporary uses for not to exceed 5 years, and you can only extend that twice, so a maximum of 10 years. The bill is silent beyond that as to what may happen after that. And can you come right back in a week later, a month later, a year later, and propose a new temporary use? And our concern from an agriculture perspective is that sequential temporary use approvals, if granted, remove the water from the land, removes the water from its originally intended purpose, irrigation being that purpose, and can over time permanently dry up that land. So we've proposed the language here that says the following expiration of a temporary transfer of an irrigation water right, being specific to irrigation, such right shall only be exercised for its adjudicated or permitted purpose for a period of time equaling not less than 50% of the period for which the temporary transfer, including extensions, was approved before becoming eligible for any further temporary use transfers. So that a holder of an irrigation water right cannot just, without limit, continue to have that right being made available to others for temporary use and in effect dry up that land and destroy the original intent of that right. I would say, Mr. Chairman, in discussion just this morning with the state engineer, he raised an issue that I think is certainly a valid one, that in some cases there may be a temporary use permit, but the water was never used under that temporary use permit. The permit was in place, but it was never utilized. It was there as a backup or a safeguard. With that in mind, I would offer for your consideration in our proposed amendment on the next to the last line, where it says including extensions was approved before becoming eligible for any further temporary use transfers, to strike the word approved and insert the word exercised. So if you had 10 years of a temporary use permit, but you never utilized it, that wouldn't preclude you from doing a future temporary use permit. But if you utilize that temporary use at any time, then you would have to put the water back on the land for its intended irrigation purpose for a period not less than 50% of the time, equal to what the right was utilized for the temporary use purpose. So changing that word from approved to exercised, I believe would address that particular set of circumstances. With that, Mr. Chairman, as I've said, we think there's a need to make these changes to clean up this law because it was written for a very narrow purpose originally, but it shouldn't become a tool to allow the abuse of long-established irrigation rights and requiring that those rights that the water continue to be used over time back on those original rights. If that's not the intent, then there should be a transfer made, not a temporary use. With that, Mr. Chairman, I'd be happy to take any questions from the committee.
Thank you, Mr. Magagna. Any questions for Mr. Magagna? Representative Provenza?
Thank you, Mr. Chairman. Mr. Magagna, your second part of your amendment dealing with essentially putting water back, I'm a little concerned about how this works for groundwater. So are we going to have to put the water back into the ground? Can you walk me through that? Because not everything is through streams or irrigation. We have lots of groundwater in Wyoming, and I'm wondering how your amendment is going to impact that use.
Go ahead.
Mr. Chairman, Representative Provenza, if I understand correctly, if the groundwater right was a right that was issued for irrigation, it's groundwater, but it's for irrigation purposes, then this would say that if it had been used for another temporary use, that water would have to be put back to irrigation. It wouldn't have any impact on the water remaining in the ground or anything, but it would be similar to a surface right, that if the right was granted for irrigation purposes and the groundwater, just like a surface water right, is subject to abandonment if it isn't utilized for the purpose for which it was granted for a period of 5 years. So it would require that the water continue to be produced, but put back on the land for the purpose for which the original right was granted.
Okay. Any more questions for Mr. Magagna? Representative Eklund?
Mr. Chairman, so in this second part of the amendment, can you think of any cases or instances in which, so let's say they had a temporary use for 5 years and this would cut it, and then they abandon or whatever, they get out of that agreement. The next time they apply, it would be 2.5 years later. Can you think of, I think, if I'm understanding this, can you think of times when that might damage the people who need the beneficial use, that are wanting the temporary agreement quicker than that 2.5 years?
Mr. Chairman, Representative Eklund, when you say it might damage the people who need the beneficial use, if I might ask, you referring not to the original holder of the irrigation right, but to the temporary user?
Yeah.
Mr. Chairman, Representative Eklund, our position would be that in that case, just like it was brought forward earlier by the state engineer, if you're going to continue to need that, then the appropriate tool, which we have in statute, is to look at a transfer of that water right, not the use of the temporary use statute. And the transfer of the water right is a much more rigorous process, provides a greater opportunity for engagement by other parties who may be harmed by that permanent transfer. So we think it's more appropriate for that reason.
Any more questions for Mr. Magagna? Seeing none, thank you very much for
Thank you,
being
Mr.
here. I
Chairman.
appreciate your influence. Any more public comment? Yeah, please come forward, both of you.
Mr. Chairman, members of the committee, I'm Jack Berger from Saratoga Multi-Generation Ranch. And I think of this bill is to move forward. These amendments that's been presented to you are critical, as Representative Eklund says, to tighten things up. As far as that in-stream flow, like I said, it was accepted last year. It's been in there all the time. That it's redundant, or, you know, that there's a AG's opinion. Like I say, opinion doesn't give me much security, and not, I mean, as, like I said, AG's opinions can change and stuff like that. So I think that's a simple thing to exempt the in-stream flow and have that explicit right there and tighten it up that way. Kind of the same thing on the, we've accepted this 5-year term with one extension, bringing it 10 years, but right now that bill just kind of stops right there and doesn't give any clarity to what happens after that. And so I think we need to clarify that too, which these amendments do. And I think that helps a lot. You know, Representative Eklund talked about the juniors and stuff, and with the language that was taken out on the Senate side, you know, that clearly diminished juniors. Now that's been taken out, and juniors and seniors are treated the same. I think that was a good thing. So anyway, I think there is some merit to this to define the term of the use and stuff, but we sure need to include that excluding the in-stream flow, just so it's clear to everybody on that and stuff. And, you know, as before this committee last year, I realized it's a little different, but I appreciated the discussion last year and stuff, and it seemed like that, good questions this year and stuff like that, so I appreciate that. So stand for any questions, Mr. Chairman.
Okay, Mr. Berger, thank you. Any questions for Mr. Berger? Representative Eklund?
Mr. Chairman, so with these amendments, you're completely comfortable with this change in statute?
I think that tightens it up enough if those amendments are accepted, you know, otherwise I think this bill's kind of dangerous. It doesn't clarify things well enough and stuff, but, you know, last year this committee killed it and because it couldn't get things cleaned up, but if we can clean things up and tighten them up with these 2 amendments, I would be okay with it.
Thank you.
Further questions? Okay, thank you. Appreciate you being here. Testimony. Mr. Moline?
Thank you, Mr. Vice Chairman. Brett Moline, Wyoming Farm Bureau, sitting in support of this bill. I appreciate that it holds, for a temporary change of use, it holds all other users harmless. That's an important aspect, especially on a temporary use. As far as the amendments, I was rather curious that they took out on the Senate side the part about the in-stream flow. I think that's important to keep in there. And I think the other amendment brought by Mr. McGagnon will be helpful as well. And with that, I would take any questions. And I've also, I think Mr. Kennedy, representing the irrigation districts, asked me to indicate their support for this bill as well. With that, I would take any questions you or the committee may have.
Thank you. Committee questions? Representative Davis.
Mr. Vice Chairman, not that I didn't review the Senate on why they took that out. Do you have why they removed that in-stream flow? Could you tell me the conversation that went around that?
If you know.
Mr. Vice Chairman, it must be a Monday. Representative, I do not. I believe there might be somebody in the room that could help clarify that, but.
Okay. Okay, thank you. Any other questions, Mr. Moline?
Thank you.
Thank you for being here. Ma'am?
Good morning, Mr. Chairman, members of the committee. Holly Kennedy here today representing the Wyoming Association of Conservation Districts. First off, I just wanted to say Thank you. I know many of you were a part of the interim process on this bill and have worked on this bill for a long time. And we do feel that the bill has come a long ways from where we started. We too would reiterate that our support of the bill moving forward is conditional on that in-stream flow language being put back into it. We do feel that that is an important safeguard, if you will, because as others have stated, that can change at any time. But I think that having it in this bill sends a clear message, sends a clear signal, and clearly sets that standard. We also, we feel that landing on the 5 years and the 10 years has come a long ways. We do want to ensure that there is some kind of backstop on that 10 years, though. We are very concerned that how open-ended it is at this time kind of leaves us in a similar position to where the bill was where we started, where people could just do it every 2 years into perpetuity. And we do feel that there should be some kind of stop back on that. We would be supportive of the stock growers' proposed language as a bit of a backstop on that. Personally, we would like to see it be every 2 years instead of every 5 years as a renewal period. And we do feel that that's more in keeping with temporary use. And that's kind of been our stance, as many of you know this whole time, is that we want to ensure that what we're doing really does speak to the temporary nature of this, because we are concerned about taking water off of the land for an extended period of time and what happens when you dry up a land and how that changes the landscape, how that changes the use, and how it doesn't meet the intended use of these waters if you are continuously taking it off of the land. So with those changes, we would be supportive of the bill, primarily, again, that in-stream flow language being added back in and ensuring that there is some kind of a stop after that 10 years to make sure that for a period of time, that water can't be applied for again.
Thank you. Questions for Ms. Kennedy?
Mr. Chairman, so if I could take a little liberty, I can answer Representative Davis's first part of that, of this deal, that what we have with this language is redundancy in statute. Putting it in here would be beneficial to anyone trying to get a temporary use agreement. But anyway, that's my take on why it was excluded. The Senate just didn't want to clutter up the green books. I think we do it all the time, but clarity in the green books is a good thing. So I'm not opposed to this amendment at all, but I think that answers part of the question.
Okay. Questions for Ms. Kennedy? Representative Davis.
Thank you, Mr. Co-Chairman. You know, if we don't put that in there, or if we do put that amendment in there, but if I'm understanding correctly, we can always revisit this and pull that amendment back out. Would you say that is possible?
Ms. Kennedy.
Mr. Chairman, Representative Davis, so just to be clear, you're saying if you go ahead and add the in-stream flow language in, then you could revisit it and take it out at a later date?
Mr. Co-Chairman, or vice versa. If it isn't in there, isn't it possible to revisit it if it does cause a problem? You know, as we understand, there is redundancy in the law right now, so I do not see the harm of having it out. It doesn't really change what is currently in the green books, does it?
Go ahead.
Representative Banks, Representative Davis. So technically you are correct, yes. But I question why we would put ourselves in a situation where we would have to scramble to fix language later on in a bill that we've already worked very thoroughly. And in a bill that went through the entirety of the interim with that language in there and has had a lot of testimony from a wide variety of groups, a wide variety of private landowners in support of having that language in there to ensure that it's never used in that way. Personally, I think it would be more proactive to go ahead and have that language in there. go ahead and meet the concerns of those that have been testifying on this bill for about 2 years now. And then, should circumstances change later on and someone feel that it needs to be used for in-stream flow, you could always take it out. But I think at this point, there's a pretty broad sentiment that that there's no appetite, or at least on the citizen part, to have it used for in-stream flow. So we do think that it would be good to add that language. I don't think it would be harmful in any way to add that language to ensure that it's not used or doesn't be perceived as being able to be used for in-stream flow purposes.
Seeing no further questions, thank you. Appreciate your testimony.
Thank you, sir.
Further public comment? Senator Hicks.
Mr. Chairman and members of the committee, want to provide a little background information on here. I think some of the stuff has been a little bit misrepresented. This actually started as a Select Water Committee topic 3 years ago. The genesis of it is you had an archaic statute that dealt with highway construction, and they had a provision in there that said, and other purposes. And so when we were working another piece of legislation, prescriptive easements for irrigation water rights conveyance, I had asked staff to go back and pull that statute in, that if you did a prescriptive easement and you did an exchange or a temporary use and didn't use that, that didn't abandon that prescriptive easement. Our staff could not find temporary water use agreements in the green books, because it was those other beneficial uses. And I want to absolutely make it clear, other beneficial uses, because that will play into the whole discussion as we get into as to whether you need in-stream flow or not. So that's how that started. So Select Water Committee took that up. We drafted a bill. It did not have, let me repeat, did not have in-stream flow in there, because it may be duplicative, it's archaic, and it's unnecessary because it's already covered under statutes. So that's where we started at. The original version of this was the Select Water Committee bill, went to the Senate Agriculture Committee 2 years ago, or a year ago, passed out of there. We did include the word in-stream flow, not because it was needed, it was because it just added clutter to the statute, but it made people feel like that they could actually support it. In fact, that didn't happen. And so when the bill came out of the Senate with that language, it came over to this body, the House Ag Committee, and you guys rejected the bill, even with that language in it. So that's the history of it. Now, to talk to the issue, we need to understand what we're dealing with. You're talking primarily, and as you indicated, Representative Eklund and Representative Stock, there's probably been more of these done in your two districts than probably anywhere in recent history. Typically, they are from agriculture, they're voluntary, and they go to industry, primarily oil and gas. Sometimes construction in my area they've been used for, but also for oil and gas. It is a voluntary agreement between the water rights holder and somebody else to enter into an agreement, and usually there's a financial contribution or enumeration for that consideration. We've done, the town of Baggs has done a number of these over the years prior to construction of High Savory, where they would have to go acquire a early territorial water right to have water for the city of Baggs. And so these have been in place for 60 years, and they've been around for a long time, and nobody's ever filed an in-stream water right. So let me talk to the issue of the in-stream water right and why. If you want to put it in there, it's a policy decision. It doesn't do anything. It's kind of like passing a law says you have to pass the law, you have to follow the law. In my opinion, it just adds clutter and confusion to something that's supposed to be clear, which is you as a water rights holder enter into a volunteer agreement with another entity to use that water. So the reason I say that it's unnecessary is you've got an Attorney General's opinion saying it can't be used for that purpose. Let's go back to Wyoming water law. Wyoming water law says the basis and the limit of any water right is beneficial use. If you can't identify a beneficial use, then you can't be granted a water right. And in-stream flow's very purpose of the beneficial use is to set a minimum amount of flow to support aquatic habitat. The very nature that you're going to do an in-stream flow is temporary in nature. It's a temporary water use agreement. That's inconsistent. It doesn't meet the beneficial use test of maintaining a baseline flow for aquatic life support. That's what an in-stream flow is for. That's the beneficial use. You can't do that on a temporary basis. It's inconsistent with the very beneficial use of the perk. That's part of the reason it's unnecessary. If you want to include it, it does nothing but just adds more language to the green books. It's a policy decision you have to make, but let's be perfectly clear. It does nothing. Now, the other language in there is okay. I would just tell you, anytime you start constraining, so those water rights issued by the state of Wyoming are a use of factory property right. You have the right to use the state's property. And the more you constrain that with these things, is you are actually dealing with somebody's property right that the state has invested with them and saying, we're going to constrain how much of that you can actually lose. Now, I would agree with some of the comments provided by Mr. McGagna. We certainly don't want to dry up land, but be cognizant of the fact that if you have a willing, and so many of you are familiar with let's say, pivot irrigation. You put a pivot in, right? And now you have got corners that are not irrigated. But under a temporary water use agreement, you can actually market those as a landowner to a drilling company or a road construction company or stuff like that. You may be precluded under the potential of the language to consider to say, well, you can only do that for 5 years, and then you do what? As long as that water right's active, even through a temporary use, it's still meeting its beneficial use. I would just tell you, be careful on how you craft that language to make sure that you don't take somebody's property right away from them by constraining how much of that temporary use that they can utilize on their voluntary agreement with another user. So I think that the language probably tries to address, nobody wants to see irrigated agriculture dried up. I also don't want to infringe on somebody else's property right to be able to utilize that water in a fashion that they deem as most beneficial for their agricultural operations. So I think you need to be cautious on how you craft that. But I just wanted to provide some clarity on where the in-stream flow was not in the original bill. That was added by the Senate a year ago with assurances that there would be some support from the groups to move that bill forward. In fact, that did not happen. There's testimony against that. And so just let's keep the record clear. Again, it's a policy decision. It does absolutely nothing. If it makes people feel good, add it. On the other issue of looking at how we do that to craft that not drying up ag land, also need to be conscious that that's somebody's property right that you're dealing with there too. So just I'd stand for any questions, Mr. Vice Chairman.
Any questions for Senator Hicks? Thank you, appreciate clearing that up. That's my recollection as well.
Thank you.
Further public testimony. Do we have a Zoom? All right,
We do.
bring them in.
Cindy McKee.
Ms. McKee.
Good morning, Mr. Chairman and the committee. Can you hear me?
Yes, please proceed.
Very good. Thank you. Well, good morning, Cindy McKee. I'm representing me and my husband, Cody. We operate a modest family cattle ranch in the Little Snake River Valley, east of Savory. And we're with you today to offer our perspectives. I want you to kind of understand what's at stake for us. We have a unique and historic 13-mile private ditch. It's our most important source of stock water and our only source of irrigation after our original supply runs out. If it weren't for that ditch, we would have we'd have almost no water all summer. So it's a very, very crucial supply for us, and we're very, very sensitive and aware of certain downstream interests who are very active. And so that makes us very, very sensitive to any proposed changes in Wyoming water statute that contradict its original intent and begin to weaken what's historically been very robust protections. We've experienced those robust protections firsthand as priority administration played out the way it was intended. And so we are very supportive of Title 41 as it was originally written, and always are cautious about changes to it. First, I want to comment that we were extremely relieved to see the original proposed amendments to 41-3-111 deleted from consideration on the Senate side. That proposed language seriously diminished the rights of the junior water rights holder. That's a huge threat to Cody and I. Here's where the risk was, and this is what hasn't come out in prior testimony. I want to really point this out. It actually turns into a subtle new burden of proof of injury on the junior water rights holder, whereas current state statute allows both the junior and the senior who feels they're being harmed the right to demand that the temporary use diversion be turned off until an investigation takes place. And that language would have diminished the rights of the junior, where that person would now have to prove to the state that they were being injured rather than demanding that it be shut off until an investigation can take place. So we asked this committee to resist any attempt to restore that amendment language. We also want to address the proposal to extend the temporary use periods to 5 years. Cody and I don't exactly have a position about the 2-year versus 5-year period. We do have a little discomfort, like others do, over the question still out there about whether after that 10-year limit, it could still come back as a fresh application. How long does this go on? One state engineer might approve repeated, temporary use. It kind of turns into an abuse. Another one might not. So I feel there's still questions out there about allowing this to go into perpetuity. Our main concern is that Wyoming doesn't find itself permanently drying up agricultural acres through perpetual renewals. I think that's a huge risk, and it's definitely not what Title 41 was written for, and these temporary changes didn't intend that, I'm quite certain. So we support the language that's suggested by Wyoming stock growers that would limit that particular use, being pulled off the land through perpetual renewals. Finally, we have a terribly grave concern over one element of Senate File 43. This is the primary reason you are hearing from us today. Last year, we made a case and were successful at convincing senators in committee to exclude the use of in-stream flows. This language appeared in Senate File 43, has been discussed, but was struck on the floor of the Senate. When advocating for this language to be struck, the proponent argued and argued before you today that about the AG opinion, about how only the state can own in-stream flow rights, and of course, it has no interest in temporarily providing fish water and then taking it away. And also the argument that this exclusion is redundant. Well, we reject this rationale very strongly. Here's why this exclusionary language is not only necessary, it's crucial. The AG opinion is just that. It's an opinion. The AG is part of the executive branch. This opinion does not carry the force of law. And even if one agrees with the AG opinion, the exclusionary language of excluding in-stream flow here is a positive kind of redundant. It supports current law, and it codifies this opinion in statute where it needs to be clearly stated so that the statute does not remain vulnerable to further tweaks. The fact is, a variety of advocates have already worked to bring legislation proposing temporary in-stream flows in Wyoming, not once, but numerous times. This is a verifiable threat. Therefore, striking the limiting language, the language that limits, can't do this for in-stream flows, striking that language was not just housekeeping. It's not just tidying up the statute. It's a chess move. And it's part of incrementally weakening Title 41. The reason I can be so sure of this is really simple. Interest downstream of us, along with other proponents, laid out a roadmap where they would like to go with this in the 2017 Wyoming legislature. I provided you a copy of Senate File 80. Had it not failed, Senate File 80 would have made it legal for any person to acquire an existing water right on a temporary basis for in-stream flow purposes, not just the state. It would have ensured that the priority date of the permanent water right, even dates from the 1800s, would follow the fish, threatening existing priority administration. And again, it would have subtly shifted the burden of proof of injury to the affected appropriator, since the Board of Control would be tasked with determining the question of injury before approval of the application and could impose a state of regulation without any prior input from the affected appropriator.
Thank you, Ms. McKee. Appreciate your testimony. Questions for Mr. McKee? Ms. McKee? Committee? Representative Eklund.
Mr. Chairman, so I guess the question I have is on the burden of proof. And if the water's shut off over a dispute, then the junior rights holder has to come up with a burden of proof. How long does that generally take? Have you ever had to do that?
Go ahead.
And I'm sorry, you're asking me that question?
Yes, Mrs. McKee.
And I want to make sure I understand. So you're asking how often I've needed to provide burden of proof?
Well,
Or I've had to provide proof that I'm being injured. You're
yeah,
asking me how often I've had to do that?
Mr. Chairman.
Go ahead.
So if you can answer it, fine. I'm sure we've got other people that might be able to answer it. I'm wondering how long is the water shut off to an irrigator or otherwise over a dispute such as we might have on this temporary use agreement? And maybe something that our state engineer can answer better.
If you've got an answer for that, Ms. McKee?
So since we have never been regulated, I don't have that experience to put it, well, excuse me, we've been regulated once informally, an emergency, we had an emergency shut off of our head gate. Someone made a claim that they didn't have stock water. It was an untrue statement. And we had to go through the appeal process. We had to appeal to the state engineer. Once we completed that appeal, then the superintendent rescinded his order. So it took 4 days.
Thank you. Any further questions? All right, Ms. McKee, thank you for being with us today. Appreciate your testimony.
Thank you.
Further public comment? Was that our only Zoom? Okay. Go ahead, Dana Engineer and Attorney General.
Thank you, Mr. Chairman. Brandon Gebhardt, State Engineer.
And Chris Brown again with the Attorney General's Office.
Mr. Chairman, I have maybe a question and a suggestion to the Stock Growers Association. And I think if there are further questions about burden of proof, maybe Mr. Brown can help clean that up as well. In the Stock Growers Amendment, my suggestion is on the second line, towards the end of that line of the second portion of the amendment. I'm on page 3, line 4. The word exercised, I suggest changing that to used. And then my question on this amendment ties to following the expiration of any temporary transfer. So the bill talks about an extension from 5 to 10 years. And so I'm wondering that under that circumstance, the way I read this, it says that before we could even consider an extension, we have to abide by this. So I didn't know if that was the intent of the body or not. So that's my question. I don't think I have a suggestion as I sit here to address that, but that's a concern.
Appreciate that. I have similar concerns. Mr. Brown?
Mr. Chairman, and just to try to address Representative Eklund's question with regard to the burden of proof, and I think maybe it's just a use of the words. And so the quick answer is there is no burden of proof, either from a senior user or a junior user. This is a regulatory process that's engaged in all the time in the state of Wyoming. What the proposed amendment, and so we're talking about amendment that's no longer in the bill, all it did was change the timing with regard to how the regulation occurs. And so under the current statute, what happens is you have a temporary exchange agreement that's been approved by the state engineer. It's in process. And if there's any senior or junior appropriator that thinks that, or that their water right is not being satisfied, all they have to do is make a demand that that be turned off, that the temporary be turned off. What happens at that point is the water commissioner goes out, completes an investigation to see if the temporary transfer is causing that the water not be supplied to whoever made the demand. And so the water gets turned off first, the commissioner does an investigation, and if the commissioner finds that that temporary purpose is not causing them not to receive water, then it gets turned back on. All the amendment did was just change the timing. It would have the water commissioner go investigate first before turning off the temporary purpose if the demand was made by a junior appropriator. So there's no burden of proof question. It's always, and under even the amendment would have been, the water commissioner, the hydrographer going out to do the investigation to see if in fact that other water user was being injured by the temporary transfer. So there's no change in burden of proof, just a change in timing of when that happened.
Appreciate that clarification. Questions for these two gentlemen? Yeah, Representative Provenza.
Thank you, Mr. Vice Chair. So in looking at the amendment that we have from stock growers, and I don't know if you have it in front of you, I guess some of my concern is, you know, say an irrigator needs to take a break, they've had a death in the family, something, they're not using that water during a period of time for reasons unforeseen. Are they going to be forced to irrigate that water to to be able to keep that under this proposed amendment with the 50%?
Go ahead if one of you.
Mr. Chairman, Representative, and I'm not sure I fully understand, but there's other provisions in the temporary water use statute, and if you're talking about abandonment, and so they're forced to use it and so that they don't risk the abandonment, the non-use of that water, there's another provision, and I believe it's in subsection B that's not in the bill, that if it's subject to a temporary use agreement that's been approved by the state engineer, then it's protected completely from any kind of an abandonment. And so I don't believe what the stock growers are provided affects that in any kind of way.
Clear. Further questions, these two gentlemen? Yeah, Representative
Mr.
Eklund.
Chairman, so one last question. If we insert this language that was taken out, does it cause any damage to anybody? Does it just clarify what's already in statute and make people comfortable, or could people be damaged by this language? Either side be damaged.
Mr. Chairman, I'll take a stab, sorry. I'll take a stab at that, and I'm not sure I fully understand your question, Representative Eklund, but I don't think, and if we're talking specifically about the proposal from the stock growers, I don't think that changes any of the statutory requirement with regard to the assessment of injury, either on the front end or the back end. And so I don't see how it hurts anybody from a policy standpoint. I think you heard from Senator Hicks with regard to folks' ability to alienate their property right, the ability to enter into these agreements to enjoy a benefit that other water users might be able to enjoy that they wouldn't if they're restricted from entering into further agreements. I don't see that as an injury to any other appropriator, which I think is what your question was geared at. But I think the other policy thing that the state engineer has talked about in the past, although I don't know if it's been today, that Senator Hicks has mentioned is, you know, that this is a flexible tool in what otherwise is a pretty rigid doctrine, right? And so one of the biggest criticisms of the doctrine of appropriation is one of its biggest strengths, which is its certainty and its rigidity. Folks that have early rights can rely on that. But folks that don't have the early rights don't have a lot of options. And so this is kind of the ability to allow some flexibility in an otherwise rigid system And if the flexible tools aren't flexible, then folks are forced to go to the permanent change. And we've heard throughout the basin, and especially some of our interstate relationships and obligations, that if we don't allow some of these temporary mechanisms in our rigid system, then it forces a permanent change, which certainly would lead to taking water off the land in a permanent way. So there's a balance, and that's a policy question.
Further questions? Representative Davis.
Thank you, Mr. Chairman, co-chairman. Would you say then, by keeping the bill simple, makes it most fluent to understand instead of putting all this other stuff in there?
Mr. Chairman and Representative, I think that cuts both ways, right? I think if you just keep some basic language in there, then and I think you've heard some testimony, at least some outstanding questions. And so if you add some more stuff, maybe it answers some of those outstanding questions, so I don't have a view on whether adding the additional language creates additional uncertainty or actually clears some things up. I think some of the things that were proposed through the process were intended to clear some things up, and it does clear some things up. I think inherently when you do that, you have the potential to raise additional questions. And I think especially the Stock Growers Amendment, that's what they're trying to do. They're trying to address those additional questions that are out there to try to provide some additional clarity. Whether it does, I think, remains to be seen, precisely to see if anybody challenges and see how it gets put into operation.
Thank you. Follow up.
So if I understood you right, then either way, you know, if you keep it just to the specific point, what we're trying to address here, there's going to be questions out there no matter what, which way we go. Is that correct?
Go ahead. Mr. Chairman and Representative, I've been doing this long enough to know that folks are going to fight about the words that relate to water.
That's why there's whiskey.
Yeah.
Is that a proposed amendment? Further questions, committee? Thank you, gentlemen. Appreciate it. Further comment before we wrap this one up? Okay, with that, we will close public testimony. Committee, what's your pleasure on the bill? Moved by Representative Provenza, seconded by Representative Ottman. Discussion on the bill.
Mr.
Representative
Chairman.
Eckman.
So I guess I'm in favor of this proposed amendment for several reasons. The first of this, I mean, we've had testimony that we don't have to have it, that it would be redundant language, duplicative language, which we've got in statute all the time. But we have been on this issue for 3 years, and I just don't want to look at it anymore. So if we can make people very comfortable with where this thing is going, I would just as soon we insert this language into statute. And the change, a bit of a compromise, maybe, I don't think it is, to this amendment, if you get to in this page 3, line 4, and you get down to the second to the last line of the proposed amendment, it says was approved before. The suggestion of the stock growers was exercised before, and the suggestion by the state engineer was used. I would like to put used in that spot as a bit of a compromise. And I realize this is redundant. Maybe we don't have to. I'm not water law expert. Maybe we don't have to have it, but clarity in the law isn't always simple. Simplifying the thing, I think, could work both ways. And I would just as soon have this in, make some junior users comfortable with what we're trying to do here, and get this law past the finish line. So I'm in favor of this amendment.
You've heard the motion on the amendment. Is there a second?
Second.
Seconded by Representative Ottman. Discussion on the amendment. I'll take a,
I'm sorry, we didn't get that. What you were saying is
oh,
that,
they might have another copy for you.
no, we have an amendment.
Oh.
There's the word exercise in exercise and the word approved. And so if you're talking, so we're looking at the second paragraph of the amendment. On the second line, Mr. Gephardt suggested amending exercise and inserting use. Is that what you're meaning?
So the line on that second line would say, including extensions was used before becoming eligible, is how the amendment was read in.
No, we're talking about this, where it says, on the second line, it says, any irrigation water right, such right shall only be exercised. Is that where you're putting in used, or is used down on the bottom there where it says approved?
Second to the last line, where it says approved.
And you're changing that to used or exercised?
I don't know what we want to do here. The motion was that second line there, second to the last line, as was used before becoming.
Instead of approved?
Yes.
I'm sorry, so maybe we should clarify, because as I understand it, Mr. Gephardt suggested changing the word exercised in the second line to used.
But that wasn't Representative Eklund's motion.
Okay, so his motion was to approve Mr. McDagna's suggestion, and his suggestion was to replace approved with exercised. Is that correct?
Mr. Chairman, thank you. So what happened was we have the amendment and then I believe the stock growers said on the second to last line, they wanted to change the word approved to exercise. And then the engineer's office said, we prefer the word used instead of exercise. So not the word exercise on the second line. Oh, now I'm getting head shake. None of us know what we're doing.
Should you pull?
Can we pull them up, Mr. Chairman?
I guess so.
Mr. Chairman, Brandon Gebhardt, State Engineer, I apologize for the confusion. So, and I was just talking to stock growers. So I think the suggestion is on the second line, the existing word exercised, that be changed to used. And then on the second to last line, the word approved be changed to exercised.
Mr. Chairman,
Yeah.
I would like to amend my amendment to read that way. So the second line of this amendment, exercise, would be switched to used. And as it's been clarified, and approved be on the second to the last line, be changed to exercised, if the second would be okay with that amendment.
Clear as mud all around? We're good? As long as they're good, we can be clear as mud. Discussion on the amendment. So I'm gonna have some discussion here. I think that this goes completely against what we're trying to do in this amendment. An in-stream flow is not a temporary use. And I think adding that language into this bill is just really mudding up the water. And so I wouldn't be in favor of this amendment. And the second part of it as well is now we're tying up people who want to go through with this, telling them that, well, you can't do with your property what you want to do with something like this. I would be in favor of keeping this bill simple, going forward in its intent, not muddying it up, keeping it for temporary use, and allowing these agreements, which are voluntary between the user and the water right holder, to continue to go on in place as was intended. And so I would be against this amendment, if there's any further discussion. Representative Provenza.
Thank you, Mr. Chairman. I want to say, I mean, ditto to that. I support the intent of the amendment and making sure that we're not drying up our lands. But I think this has unintended consequences of infringing on private property rights, telling people what they have to do with their land. And I've been opposed to bills for that reason before. And so I would like to vote for this bill. And I'm concerned if we put this amendment in there that I might not be able to at that point. So I would urge a no on the amendment and aye on the bill.
Further discussion? Representative Eklund.
So this thing went through an entire interim process, and this language seemed to make people comfortable. And now we're back to the point where we may have to look at this thing again if we don't get the bill across the finish line. And I think cluttering up statute is something we do all the time. But because people might not get back to the statute that describes in-stream flow, that it is not a temporary use purpose, because they're apt to not see that part of the statute, but see this part, they'd have clarity as to what they can and can't do and what these temporary transfers do. So I'm in favor of it because it makes our junior rights holders comfortable. And I don't think it'll add harm. We've talked about that. Could it add harm? That's concerning to all of us, but I don't think it does. So I'd just as soon insert the language in there, clutter up the green books a little bit to make clarity.
Representative Strzok.
Thank you, Vice Chair. I totally agree with Representative Eklund. The words that they kept using really bothered me. It's everybody's opinion. It was AG's opinion. You didn't, that opinion there, you change people, you change opinions. There's no security in the word opinion. That's my opinion, that's his opinion. Give them some security, put it in there, write it in there so that they have some security as landowners that are really relying on this water. And you all know my situation. If you don't have water, you don't have a ranch. You all know that. Give them some security. These people don't have any security. We change all these different people and they may have a different opinion. And I'm with Representative Eklund. There's always extra in there, but if this extra gives them security, give them security. Thank you.
Thank you. And I would stand in agreement too. The problem I see is this doesn't do what we want to do, because an in-stream flow isn't a temporary use. And so I think we would cause more confusion and more misunderstanding, because we're saying, well, now we're going to classify in-stream flows as a temporary use. And I don't think that's the intent, what we want to do here. So if we want to include that in a different statute, I think that would be the place for it. I just am under the understanding that the statute of in-stream flow is that it's not temporary. And if we open up this door, I just would hate to go down that road, is how I feel about it. Representative Davis.
Thank you, Mr. Co-Chairman. I guess I like to keep it simple, Bill, here, because we're discussing these issues right here as an amendment that should have been discussed in the interim, and I'm sure they have been brought up in the interim through this discussion, and yet they're not in the final bill. So I'm saying that these issues have been addressed or talked through or brought up before. And for whatever reason, they did not end up in this bill. And not being clear in my mind what those discussions were. I know some of these issues were in last year's bill, and for some of these issues was the reason last year's did not pass. So I'm just a little confused with trying to reinsert this stuff into a good, clean bill that we have in front of us. So I would be a no on the amendment.
Representative Eklund.
Mr. Chairman, so the first part of the amendment doesn't have beneficial use or temporary use. It has beneficial use, and I think that clears it up in statute by inserting it. It's just part of the law that's inserted in this section of the statute we're trying to change. The other part of it was that the bill had this in it up until, I believe, a committee meeting on the other side. So the vetting of the bill that we've got had this in it, and I'd like to just leave it in there. And that's why I'm in favor of leaving it alone, leaving it in there as we did, and not removing it. And, you know, for other reasons, the junior water users are more comfortable with it written as is.
Thank you. Representative Provenza?
I think, Mr. Vice Chair, trying to read how the committee's going to vote on the amendment. I think I want to divide the amendment.
Okay.
They're kind of two different things, right? The First Amendment would be the in-stream flow issue. And then the Second Amendment would be the 50% requirement.
Making sure our staff are clear on that. Okay. I think that's divisible, so go ahead with what you want to do first.
It sounds like we've got people maybe on both issues wanting one or maybe not the other. So with the in-stream flow, I think the testimony we heard was, you know, you can put it in, it doesn't matter. I don't necessarily agree with that. I don't think we should put it in. I think we've got what we need on that. And I do think, Mr. Vice Chairman, that it does muddy the water, as you've said. But the difference between the two, the divisions now is that second division isn't something that I don't know was necessarily contemplated in the same way, or isn't redundant in statute, I guess is what I should say. It is potentially new, and I think it has more infringement on the rest of the bill than necessarily the first section. So I still would urge a no on the first division, but just seeing the will of the committee, I wanted to give this an option.
Discussion on Division 1, which is the in-stream flow section. Representative Eklund.
So I guess a technical question. When we do a division like this, do we need a second? Okay. All right.
We can go forward with it. Okay. Discussion on Division 1. All right, we'll vote on Division 1. All in favor of Division 1, which is the language that would put in-stream flows back into the bill. All those in favor, please say aye.
Aye.
All those opposed, no. No. Let's do a show of hands. All in favor, raise your hand. All opposed, raise your hand. So that Division 1 would fail. We're on Division 2. Discussion on Division 2. All right, all those in favor of Division 2, which is the rest of the language of the amendment, all those in favor, please say aye.
Aye.
All those opposed, no. No. Let's do a show of hands again. All those in favor, raise your hand. All those opposed, raise your hand. Again, it would fail. Further discussion on the bill committee. Question being called on the bill. Mark?
We're voting on Senate File 43 engrossed with no amendments, correct?
Correct.
Representative Banks,
Aye.
Representative Davis,
Aye.
Representative Eklund,
No.
Representative Johnson,
Aye.
Representative Ottman,
Aye.
Representative Provenza,
Aye.
Representative Schmidt has voted aye. Representative Strock,
No.
Chairman Winter,
No.
pardon me, the vote is 5 aye, 3 no. This would pass. Wait, sorry. I can't add. 6-3.
6-3.
We'll discuss now Senate File
121.
Senate File 121, and we have Senator Boner here to explain the bill. Go ahead.
Thank you, Mr. Chairman. It's good to be here. Yeah, I guess we'll just get going here. So, hopefully this is a little bit less controversial than your previous one. Just get a little bill, thought I'd, it's okay to have fun around here every once in a while. And, I read in the paper not too long ago that people for the ethical treatment of animals wanted us to get rid of Steamboat off our license plates because they don't like rodeo. And so the idea came to me that perhaps we should have a license plate, a special license plate that shows that rodeo is in fact our official state sport. I believe the last time PETA asked us to do something similar, it was to ban rodeo, and in 2003, that's when we decided that rodeo was going to be our official state sport. So, in working with the university and our community colleges, we thought that we would give the general public this opportunity, but also do some good to raise funds for those rodeo programs at our university and community colleges. And so that's basically what the bill does, Mr. Chairman. Pretty straightforward. We based it off of the organ donor license plate. So $30 for the license plate plus whatever additional donation you would like. So that's kind of how it works. Pretty straightforward based off that current statute for the donor license plate. And nothing really too special about it, coordinated with the YDOT. You'll see that they'll be available January 1st, 2026, if the bill passes as is. And boy, that's about it, Mr. Chairman. I can go through the details if you like, but a fairly straightforward concept. So.
Any questions for Senator Boner? Yes, Representative Ottman.
Thank you, Mr. Chairman. Senator Boner, just because I see a lot of these license plates lately, and I haven't been able to ask these questions, so you are my go-to. Okay. First off, these are produced by the Department of Transportation, and are they? And how do you know how that works? I mean, do they have to go through like a design procedure? And do we have any idea how many we might sell or how they're made, and how expensive it is to make these things?
Thank you, Mr. Chairman. Yeah, so it's, I believe the cost of the department's about $2,000. So that's, pretty negligible in the hundreds of millions of dollars worth of budget they have. So no actual appropriation. I want to make that clear. They'd be able to cover it within their existing budget. I want to say the break even here is about 50 some odd plates. And so, or no, 67, excuse me, 67 plates to be break even. So I like our chances of, coming out in the green on this one. But overall, it really varies. How many, it depends on the specialty plate, how many actually get sold. UW1 is probably one of the more popular one. The wildlife conservation one is very popular. They sell thousands and thousands of those. And then you kind of go down the line. You have ones for veterans and for Gold Star families, things. Obviously, hopefully the Gold Star families ones, you hardly sell any, right? Family members who lost their loved ones in combat, it just really varies depending on the plate. Hopefully this one will be quite popular, but hopefully that answers the question. But they do go through all the design process and talking with the department, they seem excited about this possibility.
Any more questions for, yes, Representative Provenza?
Thank you, Mr. Chairman. Senator, do you know how this compares in terms of pricing? 'Cause I think you said you asked for $30. How does this compare to our conservation plates, and how did you come up with that number?
Right, it's on the low end, I'd say. I think the conservation plates, CEW plates are more like 150 or so. So certainly nothing magic about the number. I thought it'd be mostly focused on raising awareness that rodeo is our official state sport, and kind of went on the low end for that reason. Get as many plates out there as possible and relying on the voluntary donation of the public. But, you know, if you want to change it, it wouldn't hurt my feelings at all.
Any more questions? Yes, Representative Johnson.
Thank you, Chairman. And Senator Boner, I Googled that, and average person would spend between $25 and $100. So I would like to see it $50. I mean, gosh.
And Mr. Chairman, I mean, I trust the wisdom of the committee and the body as it goes through the process.
Any more questions for Senator Boner? Seeing none, thank you, sir. Appreciate you being here. Do we have an agency here? Come right up.
Thank you, Mr. Chairman, members of the committee. My name is Lacey Bruckner. I'm with the Wyoming Department of Transportation. And this Senate File 121 for the rodeo license plate falls in suit with many of our other specialty license plates. It's available for motor vehicles other than non-commercial vehicles, just like the other ones are. The department does design the plates and produces the plates in-house. And so the provisions in this bill would not be an issue for the department to administer. We also would not have a problem making the plates available by January 1st of 2026. And I would stand for any questions after that. Thank you.
Any questions? Thank you very much.
Thank you.
Okay, it doesn't look like we have any public in the room, so, any online? Okay, so we'll close public comment. So what is the pleasure of the committee? Do we have a second? Okay. It's been moved and second that we move forward.
Moved it all down.
Representative Strauch. Are you clear now? Okay, thank you. Do we have any discussion on the bill, folks, the committee?
Question.
Okay, the question's been called for. Whoops, go ahead. Representative Johnson?
Thank you, Mr. Chairman. I'd like to raise the price to $50 for the cost of the plate instead of the 30.
I didn't hear it. Raise the cost to $50.
And
Where in the bill is that?
yeah, where is that?
It says it.
So,
Senator Boner.
yeah, so, Mr. Chairman, two options there, and certainly the department could correct me, but you got the fee basically on line 14 and 15 of page 2, that's the $30. And it doesn't say $30, but that's basically the fee for the plate. Then you have the additional donation, the sentence after that, lines 15 through 18. So depending on what exactly you want to do, you could either just raise the cost of the plate and add, raise it by $20, or you could delete the basically optional donation, just make it $50. So whichever was the representative's intent, I think there's two options there.
So what's your pleasure?
Thank you, Mr. Chairman. I think just make it simpler, just say $50. I mean,
We gotta work it in somewhere.
Okay. Yes, ma'am, go ahead.
Thank you, Mr. Chairman. On page 2, line 15, that statute number 313102, That is the same statute that charges the $30 fee for other specialty plates like prestige plates, and that fee goes to the department to produce the plates. So a suggestion might be if you were wanting to increase that to 50 and have that additional monies go directly to college level rodeo to be distributed between UW and the community colleges, it might be best to add that specifically, as Senator Boner said, maybe on line 18, where it gives an optional donation of $1 or more to maybe specify the additional $20 or whatever additional monies you would want to specifically go towards the college rodeo programs and specify that amount on line 18. Thank you.
Okay, Representative Johnson?
Yeah, Mr. Chairman, I think I would agree with that. Put that $1 to $20 on line 18.
Okay.
Good with that?
So, does that look right to you, Senator Boner?
Yeah, I think so. We'll have to see how it comes out, but I think the idea is to not make it optional, but if you're doing this, it's gonna be $20, a flat $20 fee, is that correct?
Okay. Yes, Representative Strzok?
Chairman, I guess my thought was, do you feel like this may cause people to not want to do it? Like, is this, or? No, okay. It'll actually encourage them, say, hey, I'm giving $20 to the kids program for rodeo. Is that the thought here?
Go ahead.
Mr. Chairman, I don't think another $20 is going to make a difference. I think people know Wyoming's rodeo state, and $20 is nothing.
Any more questions or comments? Thank you very much.
Vote on the amendment?
Chairman,
Yes.
we had a motion, but we never had a second for that amendment. Thanks, thank you.
Can I clarify, the amendment to, on page 2, line 18, to change $1 to $20?
Yes. Okay, Representative Ottman?
Thank you, Mr. Chairman. Would we also remove or more, or keep or more in there?
Probably keep it so they can donate more if they want.
Okay.
Representative Johnson?
Yeah, let them donate as much as they want.
Okay.
On the amendment?
So, Mark, do you have any questions on the amendment? Okay. So, anyone who have the call for the question?
Yes, she did.
Oh, okay. The question's been called for? On the amendment. Yeah, so, all those in favor of the amendment signify by saying aye.
Aye.
Opposed? Motion carried. Okay. Okay, question's been called for on the bill.
We're voting on Senate File 121, with an amendment. Representative Banks.
Aye.
Representative Davis.
Aye.
Representative Eklund.
Aye.
Representative Johnson.
Aye.
Representative Ottman.
Aye.
Representative Provenza.
Aye.
Representative Schmid has voted aye. Representative Strzok.
Aye.
Chairman Winter.
Aye.
Vote is 9-0, do pass.
Okay, thank you. I guess the meeting's over with. Thanks for being here.